Hi, my name is Goldman, and I'm an attorney for Goldman Associates. And today I'd like to talk to you about an aspect of personal injury. You know, in every case where there's a personal injury, you've always got two major elements of the case. One is the pain and suffering. That's the non-economic loss. The second one is the economic loss. What's economic loss mean? Well, that's going to be our focus of today's comment. Economic loss really has to do with two things. It has to do with wage loss, and it has to do with medical expense. You know, if you're injured, you have to have surgery, who's paying that bill? Now, sometimes people have Blue Cross or some healthcare coverage that pays the bill. Sometimes not. If you don't have coverage to pay the bill, then that bill is part of the damage that the tortfeasor, that the offending person owes you to help you pay your bills. Now, what's interesting is, if you do have insurance, many times the insurance carrier, because they have to pay your bills for something that's his fault, many times they will impose a lien on the case. They will say, since we had to pay $20,000 for your bills, when you settle your case, we want 20 grand. And what does that make you do? That makes you have to include their bills in your case. Now, sometimes that's an impediment. Sometimes it's harder to settle a case and get a resolution from the other side because they don't want to pay that big medical bill. It's a real problem. It requires a skilled attorney to navigate those waters. I want to talk to you about something, though, that's very uncommon. That's a lesser known aspect of medical recovery in injury cases, and that has to do with Medicare. If you're an older individual who slipped and fell and your bills are paid by Medicare, it's a problem. You see, because if a health carrier has a lien and they don't tell the attorney, they don't impose their lien, they don't notify of their lien, then guess what? They're pretty much out of luck. The attorney does not have a duty to go find out whether or not United Healthcare or Blue Cross wants their money back. We don't have to chase people for money. On the other hand, because Medicare is part of the government, it's federal in that sense, they have a statutory lien. That means that unlike other cases, when I settle a case and there is Medicare involved, I have the duty on behalf of my client to find out how much that lien is and how to resolve it and how to get that lien paid. And what do I do then? I shift it to the tortfeasor. I make sure that the people who own the premises where my client fell, that they know about the lien. And I make sure that they discuss that with their principal. Because their exposure is not just the pain and suffering, and not just the personal injury, but they also have to consider that that lien has to be paid. And if my client has to pay it, guess what? They're going to pay it as part of the settlement. Now, there's another completely esoteric aspect of Medicare recovery. And that has to do with a little known statute which involves the Medicare Secondary Fund Recovery Act. You see, the government likes to get paid its money that it shoves out for injuries that were caused by somebody else. So when Medicare pays a surgery bill for a broken hip because of someone else's negligence, they'd like to get their money back. The question is, how do they do it? So the Secondary Recovery Act of Medicare basically set forth a cause of action and basically says that the United States of America has the right to force the wrongdoer to pay back Medicare. Not only do they have to pay it back, but this little known statute provides for double damages and attorney fees. Meaning that if there's a $10,000 bill that was caused because somebody was negligent and my client slips and they fall, and they incur that bill, that tortfeasor, that wrongdoer, not only owes the pain and suffering, but owes a potential $20,000, 10 times 2, plus attorney fees to recover it. And that same act that gives the United States the power to impose that double remedy gives private citizens the power to act on their behalf. And you know what that means? That means that as your attorney, if you have Medicare bill not only do I not have to worry that it'll negatively impact your case, I can use that bill as leverage to get you a better settlement. Because I know that if they don't want to come to the table with a decent offer, that I can tell them that they're going to owe the double penalty under the Medicare Act and the attorney fees associated with getting it. And those two items could eclipse the value of the case itself. You know what happens when we tell that to insurance companies? I'll tell you. We get a better offer.